Okay, good afternoon, everyone. Thank you for joining us at today's webinar. Firstly, I'd like to start by acknowledging and paying my respects to the traditional owners of the lands on which we meet. For us at IRiQ, we're based in Brisbane, so that's Minchinton, and it's the Jagera and Turrbal people. I also pay my respects to the traditional owners on the land for which you all as our attendees come from. We're covering a few things today, as you can see from the agenda slide. The main thing to be aware of is that there are compliance obligations from the employment perspective that come from a number of layers of the employment relationship. We're not giving legal advice today. It's more general information to help you to understand what your obligations are and where they come from. Because we're recording today, everyone is on mute, which means when we get to the question and answer session, we'll be looking to the chat box. So please put in any questions that you have into the Q&A or the chat function. We will be monitoring it as we go through. So let's get into the topics. So our first one is a general question. Where do our obligations come from when it comes to compliance? Well, there's essentially three layers to the employment relationship when it comes to obligations. We have the Fair Work Act. Now, that's our national legislation that covers all manner of employment relations matters. Importantly, the national employment standards within the Fair Work Act dictate a number of obligations for employers, so I'll be covering that shortly. The next layer is the modern award or the enterprise agreement that covers your employees. Within those industrial instruments, you'll often find there are particular obligations that you have to meet as an employer, and Riaan will be talking through that. We'll talk about the employment contracts, why we have contracts in place, how they help us to also meet our compliance obligations. We'll talk about workplace policies as well, and then we'll touch upon a couple of other key compliance mechanisms that you need to be aware of as well. So between the three of us, I hope that you find today's webinar useful and gives you some good information to take away and to consider in your workplace. So we'll start by talking about the National Employment Standards. I will just say in the next few slides, there's a lot of text in here. Now, the reason we've put text in here is so that you've got something as a resource when you read this in 6 days, 6 months time, something to refer back to when you do have that question to say, what does the NES say about this? So working through them, the NES, there are a number of them and they set obligations. So to give you an example for each one, maximum weekly hours, they set your ordinary hours of work. And the ordinary hours of work for a full-time employee are 38 per week. This is important for understanding how other obligations accrue. For example, annual leave, personal carers leave, that accrues on the basis of your ordinary hours of work. The National Employment Standard for weekly hours also defines what reasonable additional hours are. And this is an obligation for an employer when it comes to asking an employee to work additional hours, whether that request is going to be reasonable or otherwise. So you take into account factors such as the health and safety risk that arises from the additional hours, the needs of the workplace, the employee's personal circumstances, the notice given to work the additional hours, any notice given by the employee who refuses to work the additional hours. These obligations in the legislation place compliance obligations on us. Flexible working arrangements. This is one that we do actually receive a number of queries about. Now, the key thing is with flexible working arrangements, They're different from the concept of individual flexibility agreements, which are in modern awards. Flexible working arrangements clearly define who can ask for a flexible arrangement. So the employee who's a parent or has responsibility or care for a child, an employee who's a carer, has a disability, is 55 years or older, is experiencing family or domestic violence, or provides care or support to a member of their family or their household who requires it because they themselves are experiencing family and domestic violence. So those definitions are key for understanding when these compliance obligations come on to you as an employer when you're responding to a request. And there is a time frame, 21 days, as you can see on your screen. And there are certain requirements when it comes to providing a response. It needs to be in writing, and any refusal has to be based on reasonable business grounds, which are also defined somewhat in the Fair Work Act, and you have to state that. Likewise, for casual employment, if a casual seeks to convert their employment to permanent, there are obligations to respond within 21 days. There's a requirement, an obligation to consult before responding to a request. So you can see the national employment standards as minimum conditions, terms and conditions for employees, also place obligations on employers when it comes to addressing questions or concerns. So likewise, parental leave, there are compliance obligations when it comes to flexible unpaid leave, requiring a pregnant employee to take unpaid leave within 6 weeks of the expected birth date. The employer must obtain a medical certificate. Responding to requests, there are obligations for safe job transfers. There's an obligation, or a compliance obligation, I should say, in return to work guarantees. Interestingly, this is something that often gets missed as an obligation, as a compliance obligation, which is when you are employing someone to come in as a replacement employee to fill a position due to a period of parental leave. As the employer, you have a obligation, a requirement to tell them about the temporary nature of the work. So annual leave, your more significant obligation here is to not refuse, unreasonably refuse a request for annual leave. There's a further obligation. Payment on termination is the same as if the leave were being actually taken during employment. Moving forward, personal carers leave, compassionate leave, paid family and domestic violence leave, highlighting here one of the key compliance obligations, which is confidentiality when it comes to family and domestic violence leave. Community service, there's an obligation of up to 10 days payment for jury service where reasonable evidence has been provided. Long service leave, we cannot cash out long service leave under the national employment standards unless we have an order of a court to do so. If you're based in Queensland, that's the Queensland Industrial Relations Commission that will provide that order for the cashing out. But otherwise, from a compliance perspective, you cannot cash out long service leave, even if the employee asks for it. Public holidays, there's an obligation to request that an employee work on a public holiday. So this is the key thing, and I should say it was back in December. Rebecca and I spoke about this on IRiQ Talking IR. The recordings are available on our website, and it was a discussion about a long-standing, long-running case which essentially resulted in clarity about the interpretation of the National Employment Standards, which is rather than simply rostering someone to work on a public holiday, the way the Act is written is that the employer must first request the employee to work on a public holiday. So that's the key obligation there. Superannuation is now one of our national employment standards, and it's very clear on what the obligations are from an employer to comply with superannuation guarantee requirements. Notice of termination and redundancy pay. I've included a few things here on the slide for you. The key one is that as an employer, you cannot terminate someone's employment unless they have been given written notice of the day of termination. So as a compliance requirement, you must provide written notice of termination. The redundancy pay, those obligations, the NES goes into a lot of detail there about length of service and what those payment requirements are. The NES also talks about how you can reduce a redundancy payment. It is not just simply if you find another job for someone, you don't have to pay it. It can only be reduced, which may be by a bit or reduced to no payment at all, where the Fair Work Commission has provided an order to that effect. So lastly is our Fair Work Information Statement. I won't go into that in significant detail, except to say, as you can see on the screen, employers have an obligation to provide a Fair Work Information Statement to all employees. For casual employees, in addition, there's the Casual Employment Information Statement, and depending on the size of your business, small business being fewer than 15 employees, you may have additional timeframe based obligations to provide that statement more than once. And while this is not in the NES, it is in the Fair Work Act. There is a fixed term contract information statement, which is a statement that in addition to the Fair Work Information Statement must be given to fixed term employees as well. So that particular NES places a lot of compliance obligations on employers, and this may or may not be significant depending on the makeup of your workforce. So why do we need to know about our compliance obligations under the Act? Well, there are dispute mechanisms that are available. So for example, if an employer doesn't follow the process that they are required to for refusing a flexible work arrangements request, there is now the ability for an employee to lodge a dispute with the Fair Work Commission. Same for refusing to convert to permanent employee or an extension to an unpaid parental leave request. So there are definitely implications where you could find yourself in front of an independent external body to resolve a dispute. That means you lose control of the outcome. So that's something just to keep in mind in terms of the implications of not meeting your obligations. Of course, the wider obligation is that if you don't follow what's required in the Fair Work Act and the National Employment Standards, there's a non-compliance with legislation, which Riaan will be talking about a bit later when we talk about when things go wrong. Okay, so now we're going to talk about award-driven obligations, and I'll hand over to Riaan.
Thank you, Joanna. Before we begin, I do think it's just important to note that, broadly speaking, awards have similarities and they broadly follow a similar structure, but each award is different, and there's nuance and subtleties in every single award that changes the answer that you'll ultimately get. I'm sure everyone who's ever spoken to a lawyer recalls going in armed with your very simple question that must have a simple answer, only to be met with either a barrage of further questions or the inevitable, well, it'll depend answer. And as it's a bit of a meme in the legal profession, but hopefully it'll become apparent why there is that, why that it depends exists. So broadly speaking, award terms that we that we engage with employment types. I think we're all aware that you have full-time, part-time, and casual employment. Just a note on fixed-term employment: it's not actually governed by awards, but it is an important. It is a type of employment, and it is important to just be mindful of. Full-time employment, 38 ordinary hours per week. I think that's relatively straightforward. With part-time employment, it's usually defined as a regular pattern of work, less than 38 hours per week. Some awards set out that it must be agreed in writing, the hours and days, as well as start and finishing times that the employee is going to work, the part-time employee, and usually that must be set out in writing. So, for example, the SHADS award has a provision to this effect. Interestingly, usually hours above the agreed hours that the part-time employee has agreed to work, usually that will be paid as overtime, but it'll depend on the award. Casual employment. So casual employment exists in awards, but the definition for casual employment was introduced by the Fair Work legislation amendment, the Closing the Loopholes Act in 2024. A casual employee is, simply put, an employee where there's an absence of firm advance commitment to continuing and definite work. Whether someone is a casual or not is based on several indicia set out in the Fair Work Act in Section 15A. And just regarding fixed-term employment, like I said, it's not governed by awards, but important to note with fixed-term employment is that since 2022, when the Secure Jobs and Better Pay amendments came out, a fixed-term contract cannot be longer than 2 years, and that includes extensions and renewals. So in effect, you cannot have someone on a fixed-term contract for longer than 2 years. Moving on to award classification. So it's rare that an award will apply to every single employee in an industry. It's important to review the classifications that the award proposes to cover and the employees that the award proposes to cover in order to assess which employees are covered by that particular award, and importantly, what the entitlements of those employees will be. Now, to determine whether an award covers an employee, that involves more than just looking at quantitatively, this employee has, 5 similarities, and once we hit, and there are 7 in total, so that's a majority. It's you have to examine the nature and the purpose and the principal purpose of the employment. So the principal purpose test involves 2 elements, and the first is a question of fact. So it's an examination of what the employee's work and the circumstances in which the employee is employed to work, and that's for the purposes of ascertaining the principal purpose for which they're employed. And then you compare the principal purpose to the relevant classification descriptors to determine which classification applies. And again, you look at you're assessing the actual duties performed by the employee, not just simply what's on the position description or set out in the job title. The reason why this is really important to get correct, to do well, is that if you underclassify an employee, that can lead to systemic underpayments, where if an employee is classified at a lower level than they ought to have been classified, usually this will mean that you've been paying an employee at a lower rate, which poses the most significant risk. So, for example, there was a case and there've been a myriad of cases, and usually these are pursued by the Fair Work Ombudsman, which I'll touch on a bit later. But in Fair Work Ombudsman and Blue Impression, the employer misclassified an employee. So the employee was classified at a lower rate, at a lower classification than the duties that they were actually performing entitled them to be classified at. In this case, the employer also used an accounting and consulting firm to assist them. But before the facts before the court showed that the employer had the information that showed that the employee should have been classified at a higher level, and that the employer was essentially acting willfully blind. So ultimately, the penalties in this case, and bear in mind this was in 2017, so that is not too long ago, but in employment relations, that is millennia ago. Ultimately, the employer was ordered to pay around $115,000 in pecuniary penalties, in addition to rectifying the underpayments. So that's an important, that really shows how important it is. One of the aspects that's interesting, as I mentioned, all awards have their own nuances, and when it comes to confirming employment, a lot of awards have a section that determines the employee must be informed in writing of the terms of their employment, such as whether they are full-time, part-time, or casual. For example, you can find this in the Building and Construction Award and the SHADS Award. You cannot find this clause, however, in the Banking and Finance and Insurance Award. So if the simple question is, do I, in terms of the award, do I have to confirm this in writing? It will depend on the award. So always important to check. Moving on to independent contractors. Again, not specifically covered by the award, but lately we've been seeing a lot of questions around whether an employee or a worker is an independent contractor or whether they are an employee. And the reason why this is important is if you have been engaging someone as an independent contractor, if on the balance they are actually an employee, the award will be relevant to determine what that employee's entitlements were, and that will be relevant to determining whether the employee has been underpaid. Usually independent contractors don't have entitlements to annual leave, and the employer isn't required necessarily to pay superannuation and all of that. So it really is important, and we have been assisting employers with that assessment on whether a worker is an independent contractor, because it can be quite tricky. Annualized wages and wage offsetting agreements, if you've been involved in human resources or industrial relations, you'll no doubt recognize the Woolworths and Coles decisions. For a period, they were all that anyone spoke about in industrial relations, and rightly so. They are very important decisions. But in essence, just when it comes to annualized wages and wage offsetting, the important thing from this learning from these cases is that wage offsetting and agreements, valid legal mechanisms must be, the offsetting must occur within the pay period. Employees are entitled to their full entitlements in every single pay period. So in the Coles and Woolies cases, these cases related to annual salaries, specifically under the General Retail Award, which does not provide for an annualized wage arrangement clause. You can only rely on a pay period to pay period offset if this is provided for in your contracts or in the award. It's very important that your payroll will need to reflect the pay period to pay period reconciliation, and the Coles and Woolies decisions clarify that the obligation to pay wages under the award will be relating to a specific pay period. So if the award says employees must be paid fortnightly, and the Fair Work Act says that the employees must be paid in full, it means that they must be paid in full for each pay period. The sort of averaging out the peaks and troughs cannot occur outside of those particular pay periods. Moving on to consultation obligations, all awards will have consultation obligations that they impose on employers, and they require more than simply just informing an employee of a decision that has already been made. For example, where major workplace change is proposed, such as restructuring, redundancies, or significant changes to hours, the employers must provide in writing the relevant information and give the employees an opportunity to respond, and then also genuinely consider feedback on those proposed changes before making a final decision. A failure to consult can result in a breach of the award, even if the underlying decision is sound. An interesting case that came out recently is that of Poynton and Davmat. In this case, the relevant award that applied was the Children's Services Award. The employer proposed to change the employee's hours and days of work. It wasn't a part-time employee. And the matter got referred to the Fair Work Commission for dispute resolution. And what was interesting, based on the Commission's interpretation and review of the award provided that the employer could amend the hours, the days of work of the part-time employee by giving 7 days notice, but that it couldn't change the hours of work. So in that case, the specific wording of the award was very, very important in ultimately deciding the dispute. And then just finally, individual flexibility obligations. So individual flexibility arrangements, all awards will have terms to this effect. And the awards allow for variation of certain award terms, only to the effect, to the extent that the employee will be better off overall. These must be genuinely agreed to, properly documented. There is a requirement that these be distilled into writing. And importantly, individual flexibility arrangements will form part of the employee records, which Terrianne will no doubt be talking about a bit later. But for now, just returning back to the contracts of employment, I'll hand over to Jo.
Thanks so much, Riaan. So quickly speaking about contracts of employment, we often do get the query saying, why do I need a contract of employment in place? Who do I have the contract for, and what should it say? An employment contract, in short, is an agreement on terms and conditions of employment. Key to an employment contract is that once you have one in place, it represents contractual obligations from an employer's perspective. We recommend everyone has an employment contract, even the casuals, largely because it's a clarifying document, and it can also help in resolving disputes or queries or grievances that arise from, for example, the employee queries their classification, because we've just heard from Riaan, we need to include the classification in the contract. That then or we need to be clear on the classification, I should say. If it's in the contract, it's a document that helps to provide that clarity. So there are a number of reasons and benefits for having an employment contract in place. And what I just wanted to mention was that contracts should include essential terms, and we have a list of terms that we think any good contract should include, including, those that are required by an award obligation, employee records, which again Terrianne will speak to, remuneration, hours of work, warranties, probation, confidentiality, IP clauses, termination clauses, restraint clauses. Contracts are not simply a one-page, we're offering you a job document. They are detailed and they provide clarity about terms that should apply to the employment. But the key thing is, with any term that you have in the contract, it then places obligations and compliance requirements on employers. The one thing on this slide you'll see that's mentioned right at the bottom is implied terms. Not all contracts will cover key terms. There are some that are implied into the contract by fact, by law, or by custom and practice. So a well-drafted contract will cover your express terms, your essential terms, but we will also have implied terms as part of it. An example of an implied term is the duty for an employee to obey lawful and reasonable directions, which then places the obligation on the employer to make sure that any direction is in fact lawful and it is reasonable in the circumstances. Another implied term is a duty to provide wages. That's compliance for an employer. Likewise, to provide a safe workplace. Confidentiality, I mentioned before, we always like to see that very expressly provided for in the contract. The legal requirements of a contract, you can see a couple of icons on the screen. The first one is offer. When you are offering someone an employment contract, it needs to be a clear proposal from one party to another and define what that contract, what that agreement is to be about. There needs to be acceptance, so the employee accepts the offer that's been put forward by the employer. It may be expressly accepted by a signature on the contract. It may be verbally accepted, or in circumstances where the employee starts working under the terms of the contract, but they haven't signed it, it's an implied acceptance. Consideration for a contract. So there needs to be something of value exchanged, and that will normally be your wages and your terms and conditions of employment. The intention to create legal relations, so both parties must actually understand that they are entering into a binding agreement. So there are terms within your contract that will refer to that as well, in terms of accepting the terms and conditions, the intention to enter into an employment relationship. Capacity is really important as well, and this is a key one to consider for compliance. So a person can only enter into a contract if they are of sound mind, of legal age, and they're not impaired. Key to this, apprentices, trainees, school-based, we often will think someone that's entering into the workforce is of a legal age, but they're not if they're under 18 years of age. And that's often why a contract will require the parent or guardian to sign it. The final legal requirement of a contract is exactly that. It needs to be a legal document. So the contract itself must be lawful. It must not include illegal acts or illegal requirements of the employment. These obligations, and I know I've just gone through it fairly quickly, but these are key for entering into an employment contract. And they place obligations, but they can also equally be excellent ways in which an employer can meet some of those other obligations and compliance requirements that come from what we've discussed in the Fair Work Act and in awards. So I will throw over to Terrianne to talk about policies and procedures. Terrianne, over to you.
Okay, thank you, Joanna. This is an area that, as a long-time practitioner, I am very passionate about because I think as HR professionals, managers and organisational leaders, we all play a critical role in ensuring that not just policies exist, but that they're applied consistently, fairly and lawfully. From a legal compliance perspective, it's not enough to simply have policies in place. Regulators, tribunals and courts do look beyond the written document. They examine what actually happens in practice. So a well-drafted policy that isn't followed can quickly become a liability rather than a safeguard if you're not careful. So today I'll just explore why it's so important for employers to follow their own policies and procedures and how inconsistency can expose organisations to legal risk, including claims such as unfair dismissal, discrimination and breach of contract. I encourage you all to reflect throughout this session, would your organisation's decisions stand up to scrutiny if tested? So let's start by looking at the broader framework and what it means in general terms to follow policies properly and how this links to lawful and reasonable direction. Policies, they're essential in the workplace. So, why do we need them? If we've got all these other, compliance things to deal with, awards and laws and things like that, why do we have them? They provide a clear, consistent framework for decision-making and behaviour in the workplace. They help ensure compliance with legal obligations and promote fairness and transparency, and they guide managers and employees in handling day-to-day issues and more complex situations. When properly implemented, they reduce the risk of inconsistent and arbitrary decisions and support a safe and respectful work environment and place the organisation in a stronger position to respond to disputes or legal scrutiny. But they aren't just internal guidelines, they often form part of the framework against which employer conduct is assessed. So one key concept that underpins that area is the idea of lawful and reasonable directions. For a direction to be enforceable, it must meet both criteria. So it must be lawful, that is consistent with legislation, contracts and applicable industrial instruments, and it must be reasonable, meaning it is appropriate in the circumstances and proportionate to the situation. Importantly, requiring employees to comply with workplace policies will generally be considered a lawful and reasonable direction, but only if the employer is also applying those policies consistently and fairly. Where employers depart from their own procedures, it can undermine the validity of decisions that they make and expose their organisation to challenge. And this becomes especially relevant in areas where risk is heightened, such as workplace behaviour and disciplinary processes. So now let's turn to one of those key areas, workplace bullying. And I'm going to look at a few case studies after this, but we're going to look at the legal compliance. So most organisations have a bullying policy in place. It sets out what constitutes bullying behaviour, how complaints are to be raised, and the process for investigation and resolution. From a legal perspective, it's critical that these procedures are followed carefully and consistently. The most recent legislative reforms in both federal and state/territory jurisdictions, for example, the Respect at Work and closing loopholes, have created a complex network of protections against and avenues for redress for workplace bullying. So the statutory frameworks now include, at a federal level, the Fair Work Act, so anti-bullying provisions, including stop bullying orders, and these are also available in some states. General protections against adverse action taken against an employee for making a complaint about workplace bullying or harassment. And then in the state and territory jurisdiction, there are workplace health and safety obligations for persons conducting businesses or undertakings, PCBUs, to ensure health and safety of workers, including psychosocial hazards such as bullying and harassment. There are codes of practice for managing psychosocial hazards, requiring prevention strategies such as risk assessments, staff training and complaints mechanisms. And there's also workers' compensation, which can include both statutory and common law remedies for psychological injury caused by workplace bullying. The courts are also examining how internal company policies on bullying are being implemented. So let's take a look at a few recent cases where this is highlighted. So the first one we're going to look at is Swan v Monash Law. So this one goes back to 2013, but we're looking at this case because it's largely considered to be a landmark case in holding employers accountable to have in place and act on bullying and harassment policies. So Wendy Swan was employed by Monash Law Book Co-op as a retail sales assistant from July 2002 to October 2008. She alleged bullying, harassment and intimidating conduct by her manager, Mr. Cowell, which she reported to the board in March 2003. From that, the board agreed that at that time to resolve the matter by developing position descriptions for both her position and the manager's position, and introducing workplace behaviour policies which were never forthcoming. So this is where some of the case law sort of points these issues out. July 2007, so following a few years of issues, Mr. Cowell finally told Ms. Swan to get out, go and find another job and just go away. So the legal action that Ms. Swan brought, she alleged common law negligence concerning her employer's duty of care to provide a safe workplace and safe system of work for employees. And the judgment in that case was for Ms. Swan in the sum of just under $600,000. And the reason that was is because Justice Dixon found the manager's conduct would be expected by a reasonable person to humiliate, intimidate, undermine, or threaten Ms. Swan in that instance. And the employer's failure to act, Justice Dixon said the defendant's witnesses offered no plausible or compelling excuse for their failure to act. So remembering the board had said they were going to respond to the issue, and they didn't. And perhaps the most significant aspect of the judgment for the employer's obligations was where Justice Dixon rejected the employer's reliance on Ms. Swan's expressed desire. So she had said that she didn't want anything to be done about it, or she was sort of taking it on notice. So Justice Dixon said the defendant pointed to the expressed desire of the plaintiff that her allegations be taken on notice. The need for fairness to both employees by investigating the situation seems to have been surpassed by acceptance of the plaintiff's choice to accept the board's conduct as appropriate. On any view, it was the easy outcome, but that does not explain why they failed to follow through either with the process of job position descriptions, employment contracts, workplace behaviour policies, employee review and regular monitoring of the circumstances in the workplace, or with an informal response. So I guess that points to the fact that they had investigated the issue and determined that there would be an outcome, and they didn't act on it. So they had no policy in place, and this is what led to Ms. Swan, her situation and her being, or the organisation being found to be negligent in relation to her employment. So the next one is a Queensland decision, and I might have to sort of rush through some of these because I'm mindful of time. So Keegan versus Suzanne Corporation. Gabrielle Keegan was employed as an assistant store manager at Suzanne's Cairns Central Store. Ms. Keegan returned from a period of parental leave in April 2010, and there was a new store manager who'd commenced while she was on leave. The bullying behaviour that was alleged happened over a period of only 11 days upon her return, but this caused a psychiatric injury to Ms. Keegan. She claimed damages for personal injury and consequential loss arising as a result of negligence, breach of contract or breach of statutory duty by the defendant, as in Suzanne. And the judgment in her case was for the sum of over $230,000. So in terms of that, Suzanne did have a harassment and bullying policy which required line managers to treat all complaints seriously and take immediate action to investigate and resolve any harassment or bullying reported or witnessed. And all complaints to be dealt with seriously, treated seriously and impartially, and investigated as confidentially as possible, and all complaints to be referred to the People and Development Manager. So the breach that was found, though, was that it was proceeded with it was inconsistent with the policy that Suzanne had. Ms. McElrain was a manager there, and she failed to treat the complaint seriously. And this goes down to when the complaint was lodged, I think it was 4 days into her return to work from maternity leave, and it was found that it wasn't acted on at that point. So His Honour identified the telephone call on day 4 when Ms Keegan rang the Queensland business manager in tears, complaining of bullying as being the pivot point in the case. The point on the fourth day when Ms Keegan telephoned Ms Macarane in tears, complaining Ms Clark was bullying her, was a pivot point in this case. What then unfolded assumes particular significance in the determination of this matter. And so in relation to that, it was found that they didn't act in accordance with their policy, and particularly in terms of acting, expeditiously, as their policy states that they must, and taking it seriously. So you can see where things start to unravel when we're dealing with policies and procedures as well. I might skip over the next one and move on to, but you will get copies of all of the slides, etc. So you will be able to see the one that I'm talking about here. With this one, we're talking about policies and procedures and disciplinary processes, which are frequently the subject of legal scrutiny, particularly in unfair dismissal and general protections claims. In this particular case, Ebtisam Al-Bankari was employed as a specialist intervention services manager at the Western Sydney Migrant Resource Centre. She was summarily dismissed for deleting contents of an on-call phone before handing it over to a colleague, which was allegedly a breach of their company's IT policy. In this case, she applied for unfair dismissal, and the dismissal was found to be harsh, unjust and unreasonable, and reinstatement was ordered, plus compensation for lost remuneration since the dismissal. This particular one relates to the actual content of the IT policy. So whilst Deputy President Easton found that there was a breach of the procedure manual, it was wholly inadequate to put employees fairly on notice. The relevant IT provision was buried on page 64 of a 72-page manual. And the Deputy President observed in this case that the terminology in Clause 12 is legalistic, complex, and more commonly found in a commercial or government contract than in a document used by workers in a migrant assistance agency. So it might have made sense to copyright lawyers and some IT specialists, but probably nobody else. And the fact that English was not Ms. Al-Bankani's first language, the Deputy President held serious reservations about whether she would have understood the policy's terms. So I guess in essence what this was talking about was one of the key points in this one was actually that the policy was way too over the top. It was too legalistic. It wasn't able to be understood, and the communication of it was not part of how they actually implemented it. So whilst there may have been a valid reason according to the policy about not deleting the information, so it was apparently deleting some client information from the phone, it was decided that it was wholly unjust and unreasonable in the situation due to the way that the policy was worded and the length of it. This one here, there were three complainants in this one. And this one highlights the importance of having policies in place and following them consistently. So Mary Philippe, Joel Lewin and Benjamin Comer were employed in the pest commercial sales team of Rentokil Initial Proprietary Limited. Following an internal investigation, they were found to have made transfers of sales credits to colleagues without prior approval of the manager. So all three, plus one other person who'd been the recipient of some of the sales credits, were summarily dismissed for misconduct, including breach of company policy and the code of conduct. Again, this was an unfair dismissal claim, and the dismissal was found to be harsh, unjust and unreasonable, and reinstatement was ordered for all three, plus compensation for lost remuneration in this case. So this one went before Deputy President Roberts, and found that there was an absence of an explicit policy. So critically, he found that there was no written policy about transfer of sales credits which prohibited a transfer without managerial approval, and no policy of that kind which had been conveyed verbally to the applicants by any management representative of the company. Even the sales manager conceded he'd never sent any written direction to staff prohibiting the practice, and the head of sales accepted that none of the applicants in the case had been told in those exact words that the transfer of sales was prohibited. There was also entrenched practice in this organisation. So Deputy President concluded that the preponderance of the evidence favours a conclusion that there was a long-standing practice of transferring sales credits within the sales team of the respondent. And the conduct was not covert, so the master file was accessible by everyone, including management. The practice was openly discussed over a lengthy period, with no one in the sales team considering it to be a practice that was contrary to company policy. So Deputy President found that was that termination was a disproportionate response, particularly given that there didn't appear to be any particular policies, and it almost seemed to be accepted practice that it was happening anywhere, in other places as well. So again, this highlights having a proper policy and procedure in place. But I have gone over time for my session quite a bit, and I realise we've only got 5 minutes to go. So look, I won't go through any further of those. You will get those. I do recommend reading Alicia versus Vision Australia, because it is quite a landmark decision there, significantly over $1.4 million awarded damages to Mr. Alicia in that case. So I think it would be well worth a read. So essentially what this is highlighting is that policies only protect your organisation if they're followed. They are fundamental in ensuring that outcomes are legally sound, but they need to be applied consistently, fairly, and, across the organisation. Other compliance obligations, I'll now look at those. So in terms of other compliance obligations, I won't go through all of these. We have got a newsletter that we put out, which does have all of these things in there. And so you'll see that there are a number of employment records that are required or compliance items relating to employment records that you need to have in place. I'll run quickly through those couple of slides there. So there's a couple of slides with information on there that you can read through. The other one is payslip requirements. So in terms of compliance to the Act, you need to make sure that there are that you provide certain information in payslips, that you provide payslips and that there's certain information that appears in those as well. And in terms of requests for employee records, there are a number of compliance items in that space as well. Again, I won't go through those in detail, but you can see that there are compliance requirements relating to when someone requests access to or copies of their employee records, if there's inspectors or permit holders that require access, or other representatives of an employee, and other government bodies as well. So I'll leave those there in that for you, and I'll now cross back to Riaan, who'll talk through the last bit.
Thanks, Terrianne. Inevitably, things break and things go wrong, and that's where the Fair Work Ombudsman steps in. The Fair Work Ombudsman has available for the public the enforcement policy, and just briefly, the Fair Work Ombudsman enforces. Their role is to enforce compliance to the relevant legislation, compliance to awards, and employment obligations. They operate on a 3-tier system. So just briefly, at the lowest tier, they encourage voluntary compliance, which entails education and assistance. The middle tier is guided compliance. And then finally, we've got enforced compliance. The way they do that is through a variety of mechanisms, but on the more pointy end of matters. You've got compliance notices, infringement notices, litigation, and enforceable undertakings. And I'll just for a moment speak about enforceable undertakings. These generally occur where particularly larger employers or where the value of underpayments is larger, where employers have underpaid employees, and they consist of an agreement between the employer and the Ombudsman, and it's composed of the undertaking itself is composed of a correction of the underpayments, superannuation and interest on outstanding amounts on the underpayments. They may include a contrition payment, and then finally, it may also include continued audits. So the Fair Work Ombudsman will then, over time, be engaging with the employer. I just have a small slide here with, these are just for 2025. I think there were more enforceable undertakings, but just to show you the value of the contrition payments. So underpayments was always legally obliged to pay the underpayments. So in that sense, it might seem like a big amount. But particularly the contrition payments are quite significant. So really, really important to make sure that you do get your compliance right, because it can end up costing you not just, as I said, not just contrition payments, but ongoing compliance and liaising with the Fair Work Ombudsman. With that, I'll hand over back to Joe to see us off.
Okay, thank you so much, Riaan and Terrianne. So everyone, as a result of what we've been talking about, you do know that there are lots of compliance obligations as an employer, and keeping track of it all can be quite difficult. There are some great options for keeping up to date with things that are happening from an employment law perspective. Our monthly newsletter always contains informative articles, things that have been happening in the employment space, changes to awards. We also post information on our LinkedIn page, and of course our website. It has a lot of resources, news articles. It tells you how we can help you with various things as well. The details are on the final slide as well. So if you do want to subscribe to our newsletter, send us an email and we'll make that happen for you. Some of the functions that we get involved in to support businesses, we deliver in-house training and education. So our webinars to our subscriber list today, great education, great information, but we do also come into your workplace and talk about specific matters to your management team or to your wider team. We get involved in enterprise agreements as the bargaining representative or the support mechanism when it comes to drafting and compliance. Payroll audits, remediation. We also have a small business product for those of you online who have fewer than 15 employees. We have template contracts. We undertake contract reviews. I won't continue with everything on this slide because it's enough to say you can see it for yourself and see the extent of what we get involved in and what we support businesses with. What I would like to mention is our HR retainer product, where you can subscribe for a monthly fee to obtain HR and legal support from us as part of our 3 retainers: HR support, HR advisor and HR business partner. We are as involved as you need us. So if you just want to confirm a position that you're looking to take, we can do that for you as well. Now, these are our contact details so that you can contact us to talk about our newsletter, to talk about HR retainers, or any other concern that you're just wanting some expert legal or expert IR HR support with. Again, thank you for attending. What you've heard today is a lot of information about compliance obligations. I will just mention we have our next webinar in the webinar series program scheduled on the 17th of June. If you haven't got that noted in your diary, please do. It's the same time. It's a Wednesday, 12 to 1 p.m. Registration details will be made available in the next few weeks, but the topic is a really good one: dispute and complaint management, including workplace investigations. So another very practical topic where we'll be discussing dispute management and the practical steps that you can take to prevent as well as manage disputes that occur in the workplace, and that will be presented by our Legal Practice Director, Rebecca Pizzuti, as well as Terrianne Redman, who you've all had the opportunity to meet today. Again, thank you for attending. I hope that you found the webinar useful, and we look forward to connecting with you into the future and wish you a really great rest of the day. Thank you.